Start. Both functions are mutually reinforcing as mandatory under Article 22 within bracket 5 of the Constitution of India, 1950. Full stop. Not all the relevant materials have been served on the detainee, such as the telephonic conversation between the detainee and others. Full stop. The grounds of detention could have been served on the family members of the detainee even on the first occasion. Full stop. There are to have been an affidavit on the refusal of the detainee pertaining to the grounds of detention, by the official concerned. Full stop. So also, on the question of the contents having been read over to him and being read by him. Full stop. An order of detention being an exception, if two views are possible, the one in favor of the detainee should find favor with the court. Full stop. To reinforce the aforesaid submissions, learned senior counsel have placed reliance on the following decisions of this court. Full stop. Repelling the contentions of the appellant, the learned additional Solicitor General appearing for the respondents submitted that due procedure has been followed and ample opportunities were provided. Full stop. The translated version of the grounds of detention along with the relevant documents were attempted to be served upon the detainee on the very next day after his detention in due compliance of Section 3 of the Act. Full stop. A Panchnama was drawn in the presence of two independent witnesses to cover the incident of detainee's refusal in accepting the ground of detention as per the extant principles of law. Full stop. The Panchnama bears the signature of the detainee with a remark, double inverted comma, I have refused to receive any document, double inverted comma, close, this sufficiently indicates that twin test enshrined in Article 22 within bracket 5 of the Constitution of India was duly complied with. Full stop. Even in the grounds of detention, there are adequate averments clearly indicating detainees' right to make representation to the named authorities. Full stop. The contention raised is only an afterthought and therefore the present appeal deserves to be dismissed. Full stop. Despite refusal to the detainee on the first occasion in receiving the grounds of detention, a second attempt was made on 3/10/2023, and ultimately on 10/10/2023, the detainee received the ground of detention with all the relevant documents. Full stop. These chronological events amply suggest the conduct of the detainee in evading to receive the grounds of detention. Full stop. Article 22 within bracket 5 of the Constitution of India can broadly be divided into two parts. Full stop. Of these two parts, there lies an underlying duty and obligation on the part of the authorities in not only serving the grounds of detention as soon as the case may be, after due service of the detention order and communication of the grounds of detention along with the documents relied upon in the language which he understands, but also for the purpose of affording him the earliest opportunity of making a representation questioning the detention order. Full stop. Therefore, the first part involves the bounden duty of the authorities in serving the grounds of detention containing such grounds which weighed in the mind of the detaining authority in passing the detention order. Full stop. In doing so, adequate care has to be taken in communicating the grounds of detention and serving the relevant documents in the language understandable to the detainee. Full stop. The second part is with respect to his right of making the representation. Full stop. For exercising such a right, a detainee has to necessarily have adequate knowledge of the very basis of detention order. Full stop. There is a subtle difference between the background facts leading to detention order and the grounds of detention. Full stop. While the background facts are not required in detail, the grounds of detention which determine the detention order are to be found in the grounds supplied to the detainee. Full stop.